John said to let me go, I didn't get it on my own, so don't worry about it.
Councilor Casey.
Thank you. I just want to pick up where Councilor Kennedy left off. I'm not trying to put you in the hot seat.
I was.
But with respect to the sentencing guidelines, we've talked about those here, and, we hear the argument that, they're not worth the paper they're written on, they were never adopted, but, on some level, there were some pretty smart people in a room. I'm gonna assume that there was some relatively intelligent people if they were assigned to this task back in the 90s, who put some thought into this and developed these guidelines, and, I think it's kind of foolhardy to say that you shouldn't look at them at all, that they should be completely ignored, because I'm not so sure that we have changed a lot since the 1990s. If anything else, I think we've become a more violent society. I think that lawyers have become more creative with their mitigating arguments as to why people should catch a break when they've committed a violent crime, but I think it's more or less that we've moved the chairs around on the Titanic than that society has necessarily changed all that much. I don't know if society's changed over the last 100 years, never mind since the 1990s. So, if you could, I know that you answered Councilor Kennedy's question that I think what you said was you're not necessarily going to be bound by the guidelines, but it's your first criminal case. You've got to make a decision on sentencing. What is going to be your approach? What's Judge Callan's approach going to be to sentencing? Let's say it's a violent rape, okay, and there's a mandatory minimum issue and some aggravating factors. What's going to be your approach to, okay, I'm going to sit down and figure out how I'm going to sentence this person? Can you walk me through your thought process?
Well, first and foremost, I think that public safety has to be at the forefront of the judge's mind when evaluating and considering what the sentence should be. Like I answered in response to Councilor Kennedy earlier, I'm prepared to hear and listen to the arguments of counsel, having conducted the trial, heard the trial, all that information that I've been given up.
What is your opinion about lobby conferences, and what has been your experience as an attorney with respect to lobby conferences?
My own personal opinion of lobby conferences is that they're not appropriate, that that the court's business should be conducted in the court. It has an aroma of secrecy to it, I think. That in terms of the public's perception of the court system and what goes on in the court, there's a party sitting in the court that sees judges, or lawyers kind of funneling off the judge's chambers, gives the impression that something kind of secret is going on. I don't think that's appropriate, that the public has the right to see everything that goes on in the courtroom. My own personal experience is that lobby conferences at the beginning of my career were fairly prevalent for most issues. I remember being in jury charge conferences with the judge before charging a jury in the lobby, going over the instructions. I can tell you for a fact that hasn't happened in many, many years, that the charge conferences and other matters like that occur in open court, and I think that's appropriate.
And I know Councilor Kennedy asked about your criminal experience, so I'm not going to rehash, explain what your experience has been over your career. What have you done, if anything, since the nomination, or once you put your name in play with regard to this process, to get up to speed, if you will, on criminal law, criminal procedure?
I've investigated treatises on them, NCLE treatises on it. I know there's an excellent series of master practice that was originally authored by Judge Ken Smith from Western Mass. It's since been updated by, I think, Elspeth Zipper, who's taken over that role from Ken Smith. I've looked at that. I've investigated the availability of training with Flashner and other areas for judges in terms of DNA evidence type issues and murder trial type issues. I think it's important that if I am confirmed and serving as a Superior Court judge, that I actively try to use my colleagues as a source or a resource to help me get up to speed on various issues in criminal law. I understand from speaking to some judges now that there's an excellent training for Superior Court judges, and that I can, at least they were
asked about this, mandatory minimum sentencing. If you have a particular case where mandatory minimum applies, will you be able to impose a mandatory minimum? Or will you, subject yourself or open yourself up to creative arguments of counsel to perhaps do something different than impose the mandatory minimum if the crime, if there's a conviction of a particular crime?
Well, of course, there are certain mandatory minimums such as life in prison, first degree murder that are required. And there's no discretion in the judge in any sentencing law that I think that would be appropriate in any event. But I would be, in the event that I'm faced with another situation that may offer itself to a creative argument or an alternative sentencing argument, I would be open to hearing that.
So rape of a child?
I don't think that that's appropriate at all to consider an alternative sentence in that regard.
So in other words, the crime, the conviction would have to be one that you would think appropriate to consider some type of creative argument. Not, there's some that you would say are not on the table.
I consider categories of crime such as the one that you just mentioned, rape of a child, something that's so particularly heinous that we got to open to an alternative sentencing agreement in that regard. I spent a fair amount of my volunteer work over the last 20 years, particularly with children, for a very deliberate reason, to deserve our attention and support in all respects.
And I saw that in your materials, it's very admirable. I agree with you. I think that there are particular crimes that mandatory minimums are in place for a reason, and mandatory minimums have been put in place by our legislative process. And we don't elect judges, we appoint judges, and it's important that people recognize that separation of power. And it sounds like David responds to it. So, how about the Second Amendment? I'm sure that you were informed by your very informed counselor, your chairman, that I would ask about the Second Amendment.
Yes.
What's your philosophy about the Second Amendment? Your experience? Do you have an LTC? Do you hunt? Anything like that?
Well, I'm aware of the Helen McDonald series. I've had, over the course of my career with municipalities, I've certainly handled many LTC issues with the chief of police. It's certainly a right that's guaranteed by the Second Amendment, an individual right guaranteed by the Second Amendment. Some experience representing gun distributors in lawsuits, profit personal injury. I think, frankly, counsel, that any of these rights we're talking about, First Amendment rights, separation of church and state, the right to bear individual right to bear arms, that the danger is not in guillotine right, but in chipping away those rights of the citizens. As a judge, I'm particularly vigilant about that.
What do you think of the AG's recent decision with respect to copycat guns, where she has taken a different interpretation than what has been in place for about 18 years now from prior attorney generals, with respect to what that applies to?
I'm honestly not familiar with that. I haven't followed that from this perspective.
Have you read about it?
Just vaguely, I looked at some of my close friends, folks that I used to volunteer with, who are gun owners, one of them in particular is a trainer in firearms, was speaking to me one day about it, very passionate about that, frankly don't understand the issue enough to comment with any comments on it. He's very, very passionate about it, always spoke.
Yeah,
About these issues.
signs of throughout the district. Well, the Second Amendment's a real important issue for my constituents, and I know it is for people out in your area as well. You mentioned Western Mass, how beautiful it is. A lot of hunters out here, sportsmen and women, a lot of sportsman clubs. I sometimes joke and say I think there are more sportsmen and women clubs than there are grocery stores west of 128. But it's a very important issue, and you know it's an important issue when we have senators, Democratic senators in my district who have A+ ratings from Gold. They understand I appreciate your response on that. I just wanted to touch on a couple of your cases. And I did note that I was impressed to see that in the section on the JNC application where you were asked about some of your more important trials, significant legal transaction experiences. Question number 23 on page 5. It was refreshing to see, and I have to say that, I've been here since 2011. It was unusual to see the number of cases that you cited that you settled, which I think is a sign of a reasonable person. And as you probably know, you've been practicing law longer than I have. That a lot of these cases should settle, and it was refreshing to see. I think you had 3 of them in the section, or 5 cases you were asked to cite that settled. Can you just speak to your philosophy about mediation, arbitration, and what you would do as a judge? Let's say you're at a pretrial conference and everybody submitted their memos. What will be your style with respect to trying to move the parties closer together, or just a very hands-off approach? Okay, when's discovery closing, and let's get a trial date. What do you think your position will be on that?
The most effective judges that I've seen get involved in that particular circumstance don't get involved too much in the merits of the issues at all. Oftentimes, the most effective presentation by judges is when the parties are there for final pretrial meeting a week or 2 before the trial. And the judge, of course, doesn't get involved in any of the issues of the case, with the actual issues of the case. The judge certainly reminds them that a case is better off, negotiate and settle, the parties can shape and have some control over the outcome, rather than putting 14 or 16 jurors in the box to listen to the case. And I can tell you from experience that that may be why a lot of these cases of mine that I've decided to settle, because trial is a different animal than people are used to. It's filed only 100 times. You're trying a different case at 4 o'clock in the afternoon than you always started at 9. Things change. Things don't go as planned. Witnesses say things you aren't expecting. Evidence that comes in or doesn't come in. I think in terms of a rule, I remind the parties of that you're really much better off controlling your own destiny and something.
Very true, all of that. Let me ask you about the case of Richard Cormier versus Safety Insurance. I noticed that was a bench trial of 6 days, and it was a 93A 176 D claim, and you prevailed after trial. What were the injuries in that case? What was that case about?
The underlying case, I believe, was a death case. I'm sorry, the underlying case was an individual who was hurt and then developed some heart conditions as a result of the accident. The underlying case was tried. The sport case was tried to the jury, which resulted in probably $500,000 judgment against in that case, which the insurance company paid. I was then retained by the insurance company to represent its interest in a bad faith lawsuit brought by wrongful failure to settle. It was a great case. I tried it to Judge Agostini. Chris Doty was a lawyer on the other side, was a wonderful lawyer, a gentleman, and we were able to organize that case. We thousands of pages of documents as exhibits and presented.
And if you'd lost that case, would he be here testifying to you today?
Good question.
It's interesting. I look at a lot of the names in your application. Tim Burke. I see that you had a case with Tim Burke settled. How did you find him to deal with?
Times, but he was had a couple cases with him. That was one that went right to the trial in Norfolk County. But Tim and I ended up getting along. We had another case down in Barnesville 3 years later, involving an employment contract. And after those cases resolved, he called me a few years later with a question about something. I got something on me. He called me with a question, and we talked about it for a little bit. I thought that was nice that we had our issues over the years, and had enough respect for me to reach out to me and bounce
And how about Jim Menensis? So I see that you had a defamation case with him.
Jim's a great guy. I deal with him with some frequency. He had represented one of the parties in this defamation case. He also tried the underlying Cormier case. So the 160 case that I handled, the insurance company, Jim Menensis tried the underlying court case. So I got to know him pretty well on that as well. He has a wide experience. He's very good.
And what's your overall philosophy on summary judgment? Let's say you're on the bench and, I do think judges have a philosophy. You can say it's merits and, whether the standard is met, whether you grant an SJ or you grant a partial SJ. But, in speaking to some of the judges, some judges believe that people should just have if it's a close call, if it's a jump ball, people should have the day in court. What's your feeling about that?
They're rare. I think that's the law. Close call needs to be drawn in the last case. They're rare. Most of the summary judgments that I've seen are matters where the parties have basically agreed on the facts, particular dispute on the facts, and it's an interpretation of the statute or something like that. They're generally rare. Very rare.
And are you a fan of mediation to resolve cases?
By the orders in general.
In general.
In general, it really is a great tool. There's some very, very skilled mediators out there that bring parties together. And the success rate of mediation is somewhere in the line. People go to a settlement conference. They've made the mental decision in their head that they want to get it settled. Both parties or multiple parties, whatever that's mental decision they made to get it settled. Usually momentum for a day or subsequent days to actually get it done. It's a great tool for people to the outcome of the case. Frankly, sometimes it's important because parties, plaintiffs push on three parties that are owed money under a contract. Sometimes they just want to tell their story. They just want somebody to listen to. So the mediator sits and listens to the person talk, gets their story. And that's half the desire of some parties with president or something. Good mediators listen a lot.
And how many staff persons, when I say staff, I mean, how many executive legal secretaries, paralegals do you have in your firm?
There's probably 10 admins and 3 or 4 paralegals for 25 lawyers. This year, Mary Jane works for me, and my associate Jesse Gluckman is here today. And also my bottom admin. We share.
And based on your experience, you've been with the same firm, say a big firm, for a number of years. How are you going to treat the solo practitioner who comes in and not going to show up and say the dog ate my homework like Counsel Kennedy, but show up
I
with
don't have a dog that works.
a legitimate reason that you don't have all your experts' information, or you need a continuance on something, and maybe it's something that should have been done, but it's a solo practitioner. They have one secretary or paralegal, and they don't have the big firm resources. I mean, how are you going to deal with that situation? How are you going to be sympathetic to that person, if at all?
I mean, I think that Louis solo practitioners have a lot on their plate. They don't have to come to administration to fall back on. They do the deadline, they do the accounting, do all that things. So you have to be careful, especially in cases where there's a large on the other side of the soul or yours. Just recognize that there are some entities that I can tell you, with all the consideration, I estimate that probably 25 to 33% of my business, my new business, are referrals from solo practitioners from the Western counties who have a particular case that they want a referral from. We work together on those cases to mitigate them and solve and settle or to try them. And most of our repeat customers, we have been
Okay, and, one of the most important things that, I think a colleague for judge to have, among other qualities, but is modesty. And, in reviewing your application at page 9, pretty modest, you say, I'm a poor golfer, but a named companion on the golf course. So that's a pretty modest statement. We don't always see that in applications. We see, I love to golf, travel, run, but, whatever you do, cook. What's your handicap?
Embarrassing to say on the record, probably 25.
You're under oath.
25.
Well, maybe if you are confirmed, you can find a little more time to work on that.
Counselor, I don't think that's the message you would be sending to the public.
Well, it's a different speed. But I've reviewed all your materials. I find you to be incredibly articulate, well-spoken. You've got a really diverse background. One of the questions I did notice in one of your cases, you dealt with a foreign issue. Just trying to get here. Or it appeared to be anyway. Yes, and one of my question was, have you ever dealt with litigation involving the Hague Convention?
We thought we may have a Hague issue with that particular case, but never quite got there. I did learn that European law is quite different than our law here in the States in that case. And I learned quite a bit about how the Europeans use some of our legal systems to apply in that case.
I've had one, and it's very interesting. Very interesting. So I was just curious about that. But your home counsel speaks very highly of you. I've gotten a few calls about your nomination. I like your philosophies. You seem eminently qualified, so I look forward to taking the vote on your nomination next week. And I thank you for the time you afforded me, and I apologize for not having an opportunity to call you. I too am running for re-election, and I'm a solo practitioner, and sometimes I can call nominees back, and sometimes I just can't. But if I had any concerns after I reviewed your materials, I certainly would call you. But very, very strong.
Thank you.
Thank you. Yeah, ditto that from what my friend and colleague Jen Casey said. I don't really have a lot of questions, but I did want to ask you, what do you think is the most important quality that you're going to bring to the bench?
Patience. In my career, I've dealt with some difficult clients and lawyers over the years. To be patient, take a deep breath, and move forward.
Yeah, you touched on something earlier, Attorney, that I think is really important, and you were answering Counsel Casey about mediation. And that is what I say a lot, that people really want to be heard. Even if they lose the case, if it's not mediation and it's before a judge, they want to make sure that they were heard and that they got some validation from it. Of course, we all want to win, but at the end of the day, they want to know that the system is working correctly. And that is not something that we can